Friends, today's topic is regarding the non-registration of the FIR endorsed by the magistrate. The two judges bench consisting of Mr. Manojit Mandal and Jaimala Bagchi of Kolkata High Court, while disposing the anticipatory bail petition in CRM number 4792 by 2018, they have passed caustic and very grossly offensive, not even we cannot say because it is a court, they have passed stringent remarks against the attitude of the Kolkata police, particularly that of the officer in charge, Mr. Sukumar Mishra, presently working in Dinajpur district of West Bengal state. If we go into the details of the instance, so what happened is, first of all, better you know the provisions of the Crpc regarding the registration of the case. According to section 154 of the Code of Criminal Procedure, whenever the officer in charge of a police station receives information regarding the commission of a cognizable offence, if it is oral, he has to record the same, reduce the same into writing and register the so-called first information report. If it is given in writing, straight away he has to register the case 154 clause 1. So this is regarding the commission of a cognizable offence. According to 154 clause 2, he has to give a copy of the same free of cost. That means the officer in charge shall give a copy of the FIR to the complainant free of cost. According to 154 clause 3, if the officer in charge fails to register a case, then it is the prerogative to the complainant to send a copy of the same by post to the superintendent of police, who will in turn take up investigation or see that the matter is investigated. This is regarding 154 section. That means every cognizable offence should be registered by the SHO or officer in charge of the police station. Right. If it is a non-cognizable offence, according to section 155 Crpc, so the police have to give an endorsement to the complainant that it is a non-cognizable offence, and if at all they want to take up investigation in the matter, they can take permission by writing a letter to the magistrate. They can take permission from the magistrate and they can register the case and investigate the case, and they have got all the powers except the power to arrest the accused. This is 155, brief facts. So now, even though the police don't, you need not go to the police station for that matter. You can go to the court and file a private complaint also. That has also to be investigated by the police. Here, according to section 156, when you want to file a private complaint, you can do so by filing the same in the concerned magistrate court. Basing on that, the magistrate may order for inquiry or he may order for investigation. So according section 156 clause 3 Crpc, whenever the matter is entrusted or endorsed by the court to the officer in charge, then it is his duty to register the case. Now the problem comes here. The entire case, crux of the so-called CRMP 4792 is dependent on this 156 clause 3. What happened is, a person filed a complaint, private complaint in the court in Chenchal area. So it comes under Chenchal police station also. So the magistrate, having been satisfied that it is a case involving the sexual abuse of children, he referred the matter to the police under section 156, and according to 156 clause 3, they have registered a case. The matter was entrusted to the police on 13th January 2018, 13/1/2018. But to the surprising of the magistrate, the case was registered on 13/9/2018. They have taken simply a 9 months time or 8 months time to register the case. So this is the problem. This is a case of sexual assault section, that is section 4 of the POCSO Act. So it is called as penetrative sexual assault, and which is punishable for, if proved, punishable for not less than 7 years, may be extended up to life imprisonment or death sentence or so. When such is the gravity of the case, when such offence, the police failed to register the case for 8 months. They have slept over the matter for 8 months, and ultimately on 13th September they registered the case, but still no action. Now, the situation has come like this. The accused in the particular case, this case relates to crime number 579 by 2018 of Chenchal Police Station, registered under section 4 of the Prevention of Children from Sexual Offences Act 2012. Alright, so this case has taken so many months for registration. Now, this man, Abdul Khalik, who is the accused in the so-called offence, he filed a petition under section 437 CRPC for anticipatory bail. So while deciding the anticipatory bail, the High Court was stunned to see that the case was registered after 8 months. So definitely they granted him anticipatory bail. It's a different part. Coming to this aspect of registration of the cause, the High Court has given scathing remarks because they relied or they cited the previous very famous decided case of Lalita Kumari versus State of Uttar Pradesh and others, decided in the year 2014. So according to that, so previously also there were so many decided cases like Prakash Badal versus State of Punjab, and also Bhajanlal versus State of Haryana. So many cases were there where the Supreme Court has asked the police to register the case immediately. So according to section 154 CRPC, there is no other go for the police except to register the case in a cognizable offence. But in certain cases, according to Shekhar Nafade, who represented the state of Maharashtra, he stated that some leverage is given to the police in certain matters. So they have got the they have got the advantage, or they have got the rule of at least separating the chaff from the grain, or rule of preliminary inquiry. They have to conduct rule of preliminary inquiry because in CBI cases, whenever an allegation of corruption or an allegation of something comes to their notice, what they will call, they will do some preliminary investigation, and then only they will register the cases. So, according to Shekhar Nafade, they stated that the police have got the leverage of conducting the so-called preliminary inquiry. But in which cases? So it depends on facts and circumstances of each and every case. Ultimately, while deciding the Lalit Kumari case, the Supreme Court has given clear-cut directions that the police have to register cases where they are cognizable offence. But the leverage is given in 4 cases. Number 1, the police can conduct a preliminary inquiry basically in matrimonial disputes like divorce, maintenance, all these things, matrimonial offences, because they have to send them for counseling, other things, they may take some time. Second is regarding business or company law or misappropriation of high amounts, because company law is different, the accounts have to be verified, and misappropriation may take place in so many aspects, so they have to conduct some preliminary inquiry to get the records. Number 3, medical negligence cases. So you can't fix up medical negligence for each and every act, because doctors are there to save the lives of people and they try their best to save the lives of the people, but sometimes there may be negligence on their part. So it has to be inquired whether it is a case under the so-called Consumer Protection Act, whether there is a willful negligence or whether there is like culpable negligence. All these things they have to verify. For that they need some more time. So like this, some leverage was given in certain cases, but in other cases they have to register the FIR. Now the Kolkata High Court, basing on the judgment of Lalita Kumari, now they have also opined why the FIR should be registered at the earliest point of time, because it is the rule of law That means every person should have access to the criminal law, access to the law. Therefore, according to rule of law, the case should be registered. That is rule of law. Second is the judicial process or the investigative process. Access to the justice system will start when FIR is registered. Otherwise, they will keep cool. They don't investigate the case. Therefore, access to the justice system, or the state should acknowledge, or the state should come to know that some offence has taken place. That's point number 2. Point number 3, what they will say, swift investigation will be started, and there is chance of prevention of recurrence of the offence, prevention of the crime. It is the advantage of registration of immediate case. Third is definitely the concocted FIRs or belated FIRs, or the FIRs which were given after tantamount or briefing by somebody, they will be avoided. So, immediate registration of the case gives the, basing on the following above points, definitely the case can be registered, the case can be investigated. Approach. You all know the goal of the investigation is truth. So, truth will come out. Now, the High Court, Kolkata High Court has given stringent directions that whenever, no doubt, according to section 154, they have to register the case, there is no appeal. So, coming to the point of 156 clause 3, the police are directed, of course, first of all, the magistrate is directed to send the endorsement within 12 hours or within 1 day to the immediate, as soon as possible, to the concerned court. So, after receipt of the endorsement, after receipt of the private complaint, it is the duty of the police to register and send a copy of the FIR to the court within 24 hours. So, they have to register the case after getting the endorsement from the magistrate within 24 hours. If not, they will be taken to task. Disciplinary action should be followed, and also the magistrate is at liberty to take action under section 166A of the Indian Penal Code. Friends, you all well know 166A. Whenever a case of assault on woman is coming to the notice of the police, and if they fail to register the case, he is the concerned police officer is liable for punishment under section 168. It may be up to 6 months. Similarly, here also, the magistrate also can invoke the provisions of section 166A also. But more than that, disciplinary proceedings should be initiated by the Director General of Police, and this copy was the judgment copy or the bail order copy was sent to the Chief Secretary of the Kolkata, West Bengal State, and also to the Director General of Police with instructions that they should give directions to the concerned police officer. Now, as regards the bail petition, since there was a delay in the registration of the case, and of course, the respondent Sukumar Mishro, he has given an affidavit, of course, which is vague, which is hapless, which is not liked by the court. But in that, they have clearly stated that there were pending disputes between both the families, that is, family of Abdul Khalik and the others, and they have been debating so many cases. But whatever it is, the cases are pending. Even the allegation or the response or comment by the Attorney General, that is Advocate General, on behalf of West Bengal Police is that there were so many pending cases and the petitioner is a litigant, therefore they wanted to conduct the preliminary inquiry, for which the court did not accept. Now, he was given anticipatory bail, of course, with some conditions that he should not move out and he should not move in and around that Chanchal police station, and he has to stamp the passport and he has to cooperate with the investigation and he has to inform the officer in charge whenever he shifts his residence from his normal residence to other place within one country, things like that. And if at all he is arrested, he should be released on bail after furnishing 2 sureties for the amount of rupees 10,000. So this is the crux of the case. Friends, remember, particularly police officers. Normally, I have seen so many people, when once, of course, the case is registered under 154, it's okay. Let us not bother about it. As regards 156 class 3 cases, normally there will be delay on the part of the judicial staff also to send the FIR. Of course, nowadays they are handing over to the court constable. Even though there is a delay, please remember you have to register the case. We have seen so many cases. The case comes from the court, then the SI, SHO or nowadays CI. He will keep it in stable and forgets. So after 6 or 7 months, when the reminder comes from the court, then only they will open their read and they register a case. There are occasions where the cases were not registered for years together, particularly in Prakasham district, and I am sure that this happens everywhere in Andhra Pradesh or maybe entire India also, there is no doubt. So friends, as police officers, you have to register the case. After all, what is you are going to lose by nowadays? In our days, we have to prepare copy by carbon process, then stencil process has come. After the time of retirement only, the so-called computers have come. Now you are very happy. The computer, just you take a Xerox copy and give a copy free to the complaint, register case. After all, then investigation will be in your hands and you can take up any decision. Nobody will question. But if you don't register the case, definitely you will fall a prey and legal as well as defense action will avoid you. So please remember this case law and be prompt in registering cases as police officers right from the rank of SHO. There are certain SIs acting as SHOs and CS also. Please remember the guidelines. Thank you.